Reading of article, no penalty in case of commission of illegal act without mens rea. Authored by CA Bimal Jain sir. The Honorable Delhi High Court in Rajeev Khatri versus Commissioner of Custom 2013 set aside the penalty order passed under Section 112 Clause A of the Customs Act 1962 and held that assessee cannot be penalized for abating the illegal import as there is no evidence that assessee has knowledge of the import of prohibited goods. Fact of the case is Rajiv Khatri, the appellant, was a G card holder of Messr G&D Cargo Movers, a licensed custom broker. The appellant had filed the bill of entry for importing goods which were later found illegally imported. A show cause notice dated September 26, 2013 was issued to the importer as well as to the appellant. The adjudicating authority found that the goods had been misdeclared and the import of such goods was prohibited, and thus such goods were liable for confiscation. Apart from directing confiscation, adjudicating authority inter alia imposed penalty on the applicant, including penalty under Section 112 Clause A of the Customs Act. Accordingly, the adjudicating authority passed an order dated January 2, 2018 in inter alia imposing penalty under Section 112 Clause A of the Customs Act. The appellant filed an appeal before the CSTAT New Delhi challenging the order in original. The CSTAT wide order dated 4th of June 2020 held that the penalty imposed was disproportionate and reduced the quantum of penalty. Agreed with the impugned order, the appellant filed the writ before the Honorable Delhi High Court. Issue in the case was whether a person who imports goods without knowing that such goods are prohibited for import could be penalized under the Customs Act for abetting such import. Held that the Honorable Delhi High Court held as under relied upon the judgment of Messrs. Amrit Lakshmi Machine Works and another versus the Commissioner of Customs 2016, wherein the Honorable Bombay High Court held that imposing penalty upon a debtor without any mens rea on his part would bring all business to a halt, as even innocent felicitation provided by a person who has made possible the act or omission to act possible could result in imposing of penalty. Observed that mens rea is necessary element for imposing penalty under Section 112 Clause A of the Customs Act. The penalty imposed for failure to perform a civil obligation is required to be distinguished from penalty imposed as a punishment for committing a crime. Held that the penalty cannot be imposed on the appellant as he had no knowledge of the act committed by him and the act was done without mens rea. Thank you. You can read this article in the article section in onlinetaxupdate.com. Thank you.